Your Lordship, kindly to mention two similar matter, my lord. My lord, here, my lord, the contract that was awarded to the petitioner for Himalayan Railway, that is a heritage site, that has expired, my lord.
Inclusion.
Inclusion, my lord.
Not now.
But there is a very urgent, my lord. Otherwise, I could not have.
I'll be not sitting.
My lord, let it appear, my lord. Kindly, my lord. Let it appear in the list, my lord.
Of matter appeared in the list. You mentioned in the month of March.
Well, that will be because the contract has expired. Now they are enjoying unlawfully enjoying their malware property.
Take up before 5th March. What is the need?
Then your lordship kindly then it appear. Let me
mention in the month of March.
This is also a hearing matter, Lordship. The first order passed by the Honorable Justice Lapita Banerjee. Now, Lordship, I have challenged the penalty order that has been, my increment has been withheld. I have challenged that order and
For inclusion.
Lordship.
Not now.
But there's some urgency, Lordship. Next year I'll be retired.
Urgency, I will be not here.
No, next year my client will be retired, Lordship.
Mentioned before any other bench who can
There's
take
no
up
hearing
the
bench
matter.
except you, Lordship. There's no hearing bench.
I will be not here. You mentioned in the month of March when I will be here.
Lordship, may I have no inclusion, Lordship. I am praying for restoration of.
Restoration, yes. March. After 5th.
Well, kindly, Lordship.
No, only listing what will be the purpose.
You'll be retired on next year, Lordship.
Regular bench, there are so many regular bench. You mentioned before that.
There's no regular bench, Lordship. This is a hearing matter. That's
you mentioned in the
I
month
mentioned
of March, I will add.
Lordship.
Yes.
I'm for that.
You are for the petitioner?
Yes, ma'am.
CRR 1672 of 2001 is thus allowed. Connected application, if any, are also thus disposed of. The judgment dated 6/7/2021 passed by the learned session judge Bakura and the judgment dated 9 February 1999 passed by the learned sub-divisional judicial magistrate Bishnupur are hereby set aside.
Deeply appreciated.
Petitioner is in jail.
Yes, ma'am.
The petitioner shall be at liberty forthwith if he is not wanted in any other case upon execution of bond to the satisfaction of learned SEGM.
SEGM, madam.
SEGM Bishnupur.
Bishnupur.
Which shall remain in force for a period of 6 months in terms of section 437A of the CRPC corresponding to section 481 of the BNSS 2023.
Deeply. Deeply appreciated.
Well, I am for the
CRR 933 of 2017 is also allowed. CRAN 2, CRAN 3 are also thus disposed of. Consequently, the proceeding being Arambagh PS case number 1066 of 2016 dated 11/11/2016 under section 406, 420 of the Indian Penal Code corresponding to GR number 2090 of 2016 pending before the Court of Learned Additional Chief Judicial Magistrate at Arambagh District, Hubli is hereby quashed insofar as the petitioner is concerned. An order passed therein against the present petitioner is also set aside.
Well, may I get back the case diary?
Yes, case diary. Return the case diary.
I am for the petitioner.
I appear for the KMDA.
My senior Mr. Bikash Ranjan Bhattacharya, and a senior advocate is online.
On 4th,
On the last occasion, there is a direction upon the respondent authority to supply the note and job chart in respect of the petitioner service till and with the advance copy that has not been served.
Why, sir? At least note if there is no job chart, there is no job
Since
card.
2013, the interim order.
My lord, on last 4th
Last
February,
message
4th February.
you have
Yes, yes, my
submitted
lord.
before
May I,
this
may I?
court that
In fact, these disciplinary proceedings cannot at all stand. This is so vague vis-a-vis the petitioner. He was a head head examiner. How he had the authority to change the conditions? He worked under the superintending engineer.
first of all it should be ascertained that what is the duty.
That's the basic thing. And without supplying
Knowing
that,
the duty, how can a proceeding can be
that
initiated?
is the basic point. My lord is absolutely on the pregnant issue. The proceedings cannot continue in absence of the specific duty charge and specific allegation.
The office or department is unable to say the duty of the
Yes.
petitioner, how they can proceed it.
Yes, that's the basic point. No, my lord is absolutely at the right point.
If that be the
That was
submission,
my first question, and this question was also posed by the
And
then
yes, honorable.
bench.
yes. My lord, here, thereafter, the order dated 5th March 2020, I placed on earlier occasion when your lordship
I
heard the
remember
matter.
everything. Just
Yes.
you indicate whether do you have note or not.
Yes.
If you
That
do
note,
not have
my
note,
lord wanted
then
to
I
see
will
that.
proceed.
My lord, we were on 4th, last occasion, lordship was pleased to fix the matter on 11th March. On the 4th February order, lordship will find they have mentioned citing urgency.
Because
On
urgency
11th
is
March,
my lord, the
on
petitioner
4th February order, kindly have a look.
my lord, petitioner is going
Oh,
to
to be
return on
mentioned.
28th
So
February.
this is for correction.
No, for correction, not for correction.
Actually,
But the petitioner,
Matter is already fixed on
petitioner
11th
is
March.
going to return on 28th February 2026. That's why I mentioned the matter.
My lord, the matter is pending since.
My lord, may I interrupt, Lord? With
If-
due respect, the
if-
question is
if-
not which
if
date.
it
Question
is so
is
urgency,
Then he is
lord.
going to retire.
28th February.
Any date, lordship, fix any date, because we were under the impression the matter would be taken up on 11th March.
Can you take it up tomorrow?
Tomorrow I will be not here.
On the next
Then-
Friday. After
next
tomorrow.
week, would you lordship be sitting on in the next week, if possible, on the next Wednesday?
Wednesday I will be not here.
Well, day after
Let-
tomorrow.
No, day after tomorrow. I need to come prepared also, because the points now raised.
What would be
Lord,
what would be the difficulty if it would be fixed on March?
What
the
is
difficulty is, Lord, he will be retiring without getting the benefits. All his benefits have been withheld because of pendants of this proceeding.
And the promotion also.
my lord? With
This
due
case is
respect to my
pending
learned
since
senior friend,
2013.
My lord,
Hurry from both sides.
We have
But now
mentioned
I am not sitting in next week. I'll
they are
come
citing
on 5th.
my lord, you will see on 5th.
11th,
that will-
11th March, I have already fixed this matter.
already.
No, but if your lordship Lord can accommodate Lord in this week, the next Friday, then Lord, this
Friday.
person gets the
After
relief.
Both parties are ready, then I can accommodate.
My lord,
Kindly
not
take it up day after tomorrow.
not
It's a
in this.
question of production of the record which they could not do. How can they
In
prepare
this,
it?
But
this
he
will
is
not.
unable to produce the notes.
Yes,
even
that
today.
I am to in terms of this order, I am to supply the copy and also to produce before
We
this
can
honorable
take
court.
up at 11th March.
As your
What
lordship
difference? What difference?
But Lord, the difference
Few
would be,
days,
Lord,
few
that
days,
his
11th.
retirement, my lord will kindly please to record that his retirement would not in any way affect the entitlement of the benefits if ultimately succeeds.
Definitely that would be
Definitely,
difficult.
Kindly record this.
that,
Now,
that,
unless your lordship records, Lord, the authority is so animous to him.
how they can decide. Already terminated.
No.
They have already been-
Working.
He's working.
Yes.
He's getting pension. No, he's
Salary.
getting salary.
Salary, he's getting salary.
So I have to change.
Let,
That
let the direction,
In that respect,
yes,
only
let the direction of production be peremptory.
that production
Yes.
does not arise, my lord,
He-
after
he
the
is,
5th March
he-
order.
taking undertaking that he will supply within this week.
Within this week, I shall
Yes,
supply.
but that should be peremptory. They have been taking time on this ground since long time.
We are not taking
supply
now.
of
I'm deeply obliged.
Lord, I am for the respondent bank.
yes. What is the case?
My lord, writ petitioner, being a woman manor, wanted to self-employment as well as the employment of the others in the district of Purulia. Or under the scheme, rural unemployment scheme of the government of West Bengal. He preferred an application to the district general manager, district general manager of the district of West Bengal small scale organization, my lord. In the year on 27/8/2004.
No, writ petitioner is here. Who is writ petitioner?
Jayanti Karmakar, my lord.
Jayanti Karmakar.
Jayanti Karmakar. Just background I am stating, my lord. His scheme was approved. And she was
By
directed
central,
to
by which government?
by the DIC, district industry center. And thereafter, sponsoring the program to the bank, that is respondent appearing for the bank, that is Cooperative Societies Bank, my lord. District Cooperative Societies Bank for payment of loan, everything. Therefore,
Under
my
that
lord,
scheme.
under the scheme, my lord. Loan was sanctioned, my lord. Have a look at, my lord. Page.
What was
Page,
the amount
page
of
19, page 19A, my lord.
19A?
19A, my lord.
Yes, 19A.
West Bengal Cooperative Agriculture and Rural Development Bank Limited, addressed to the Jagannath
eligible Why you have not filed the type copy?
My lord, type copy 19A is my
Oh,
type copy.
19A, yes.
Type copy, my lord.
Yes.
My lord, may I read, my lord? Please arrange, my lord. In this matter, my lord, a quotation was called for by the district industry, and quotation was also submitted for assessment of expenditure or amount of loan, my lord.
Who has submitted this? This was submitted by whom? District?
Page 18, my lord. Page 18.
General manager?
General manager.
No, who has
And
submitted
consult
this?
the bank. Consult the bank for loan for establishment of the small scale industries by the petitioner, my lord.
No, who has submitted this quotation?
Quotation submitted by the lead petitioner, my lord, because that is essential document for assessment of expenditure, my lord.
And this was submitted to the Jagannath Engineering.
Jagannath obtained from the Jagannath Engineering.
Okay.
Now, my lord, bank sent the delivery order was placed to the private respondent Jagannath Enterprises with amount of check for rupees 4,39,530. My lord, just time read, my lord. Please arrange to deliver the following items as per your quotation reference this nil dated 31st 10/2003. Srimati Jayanti Karmakar and others. Village Bigdi Post.
Skip those skip.
My lord,
Skip those
just
lines.
operative portion I am putting. On behalf of them, bank is writing, my lord. On behalf of them, Srimati Jayanti Karmakar, we take delivery of the following items. Item interest payment of rupees 4,39,530. So this account pay was a check. A direction was issued to the supplier, that is Jagannath Enterprise, to give the delivery of the machineries to the petitioner, my lord.
Upon receiving the draft.
And joint.
Upon receiving the draft.
Yes, my lord. And the Jayanti Karmakar, on behalf of the bank, will receive the machineries, not at his own efforts. On behalf of them, Jayanti Karmakar will take delivery of the following. Next, my operative portion, my lord. Check number this and this was payment. This is important, my lord. You are requested to submit concerned bill, received copy of the challan, etc. To this end, please arrange printing of the words hypo plus financed by the WBSC ARDB Bank Limited, Purulia branch, on the body of the following machineries. So it was hypocriticated to the bank, my lord.
Definitely.
Yes, my lord. Definitely, my lord. And here, my lord, what is the role, my lord? Just for convenience of your lordship, my lord, very step by step I am submitting my fair judgment, my lord. Because there is a grave unfair act is committed by the bank, my lord. I am coming, my lord, one by one. For the convenience.
No, whether you have received the items.
My lord, that I am coming, my lord. For the convenience of the court, my lord, date of date and the written notes, my lord. Next, my lord. My lord, page 20, my lord. Of the writ petition.
Yes, page 20.
So for the convenience of the court. Argument আমি দেবো তো কোর্টকে।
No, actually, argument of argument end দিবেন তা
written notes of argument for the convenience of the court, not for you.
Yes, please. You solve the copy. Where is the problem? You solve the copy.
My lord,
written notes of argument. Reply.
Copy now.
And now we come to the page number 20.
ঠিক আছে।
Okay, please come to page number 20.
Page 20, my lord. With reference to your order of such and such, dated ato, as per the quotation dated ato, the name will be delivered at the, এটা কি লিখেছে রে ভাই?
Same will be delivered on 8.
Will be delivered on 8/2006. My lord, then it was delivered, my
This
lord.
letter was issued in favor of Messrs. United Re-Rolling Mill.
That
Who
is
the
the
owner of
that
this?
is the name of the small scale industries established to be established by the petitioner, my lord. That is the name. My lord, out of 3 items, my lord, page 21, my lord, 2 items, that is sheet rolling mill fitted with 4 rolls, steel box, this on this side, for rupees 2,50,000, and cell roll cutting machine with complete parts. 17,500 total, 2,69,000 67,500. These 2 items. But main item, my lord, diesel engine oil, my lord. Without the diesel engine, how it will function, my lord? Page 22, my lord. With reference to your order of the maintenance and the material named as diesel oil engine with the delivery will be delivered after 2 weeks. So these 2 items were delivered and main item was undelivered and stated that it will be delivered. This is the root of all dispute and litigation in the present petition, my lord.
Diesel has not been supplied
No, my lord. That is the
even after expiry of 2 weeks.
2 weeks, not, my lord. Years after years, my lord. I am coming, my lord. This was not submitted. The writ petitioner first requested the district engineer, district industry center for non-supply of the diesel engine, and with a request to take up the matter with the supplier and the bank.
Where is that? Which page?
Page 23, my lord.
43.
23.
23. 23 is the letter written by general manager to the Jagannath engineer
Jagannath Enterprises.
on the basis of
On the
your
basis of the request made by the
petitioner.
petitioner. This is dated, my lord, 28/6/2006. That is 2004-5. This is 2006. Then, my lord, bank, my lord. In addition, bank, my lord, on 23rd/8/2006, page number 25, my lord. Same request was made or asked the supplier to supply the diesel engine oil. This is the date, my lord, 23/8/2006, my lord. This is a very, very important date, my lord. Since, my lord, non-receipt of diesel engine valve, oil engine, my lord, so functioning of the machineries cannot be take place, my lord. So, but again and again, bank asking the petitioner, why you are not started your functioning? But they are well aware that the main thing, the diesel oil engine, was not supplied till that date. And bank itself made a request in 16 November 2006 to the Jagannath Enterprises, page 27, my lord.
You have made party to the Jagannath engineer here in this case.
Private party, my lord. Respondent number.
Have you served the copy to the
Copy, my lord, not one, my lord. 2 times. My lord, it is the direction of your lordship, my lord, in courtroom number 23, my lord. Since it is an old matter, let there be a service of fresh service. So I complied the order and submitted all documents, my lord. Thereafter, only one receipt was wanting, my lord.
In the last
That-
occasion, you have sought for adjournment that no copy has been served upon them. Only you have submitted affidavit enclosing the,
No, affidavit of service after that definitely submitted.
no, that was not affected. The service was not affected.
Affidavit of service again.
You have to serve the copy to the private respondent.
Once, my lord. Learned counsel will admit definitely. Service to pay.
Certainly not.
Huh?
He did
No, no,
not
you
serve.
are appearing, there is no need to.
No, he did not serve upon the private respondent number 6. Till date, after
My
after
lord,
the
this
expiry
is the
of
copy, my lord. Definitely, my lord, service.
Not,
the case was filed.
not
my lord.
affected. Service has not been affected.
My lord, that is the for that occasion. Again, your lordship passed the order to
Last
complete the justice.
occasion, two
Thereafter,
affidavit
another
of
order was there.
filed by the petitioner in
There
court
was
is
another
taken
order, my
forward on request of the learned counsel for the petitioner case is stand adjourned.
Second time I have served again and submitted the document, my lord.
Yeah.
Affidavit in opposition.
You see where you have affected
My
service.
lord, for the last 16 years, they are not serving the copy of the same to the private respondent. And even he is showing that so many letters was issued to the private respondent, but not a single letter.
No, no.
He asked the supplier to
Where
supply
is the
same
item delivered?
to
Why
them.
you are not assisting your senior?
I
Where
did
is
delivery
the
only when is the
service?
respondent number 1, my lord. This was all submitted, my lord, and again the
You have
respondent
only submitted the postal receipt.
postal
that
receipt,
will-
everything here, my lord. This
I need the postal report whether the item was delivered to the private respondent or not. Where is the track report?
my lord, my lord. Yeah. Everything is here, my lord. This is the track.
Reply.
Yes, my lord,
That
for
is
the
there
last
to
6
submit.
years, they have not been
My
filing
lord,
the
what he
reply.
submitted, my lord. Just, my lord.
Do
I
you
can-
want to file your reply?
Yes, my lord.
Where is
I
that?
can
Did not
reply, my
submit for
lord.
the last
My
6
lord.
years.
Please,
You have
please.
already filed.
Yes, my lord.
Reply
Please.
already filed.
Reply already filed, my lord.
Not a
This is unexpected. I am coming. How much degree of unfair submission was made before your lordship, my lord? I will put the every document, my lord, and it is here, my lord.
Okay, no problem.
My
You
lord.
serve upon the
My
private
lord,
respondent
after
and come.
receiving, my lord, service completed, he may not receive, but this bank definitely received, my lord. And upon
I am
which
not asking to serve the bank.
private respondent, my lord.
Yes, private respondent.
My lord, whether the court has received the copy of the reply.
Reply to उन्हीं से file
Yes, then direct to serve a copy upon the respondent back.
You serve the copy of reply.
Affidavit of reply, served in the year
Is there any receipt of the bank that they have supplied
2019,
the
my lord.
copy?
Reply.
My lord, writ petition filed in the year 2009.
Please supply a copy of reply to the respondent. Bank. In course of this today.
Okay. Okay, dear rich. Sure.
Matter will appear on 11th March In
11
the
March.
meantime, you serve the copy to the private respondent number 6 and file affidavit of service on the adjourned date. তুমি কি বসে আছো দেখো ওখানে ডিকটেশন দিয়ে none appears on behalf of the
Lordship, in this matter, for the petitioner, Lordship, in this matter, I am led by Mr. John Lanet, Senior Counsel Jonathan Mitro. Lordship, due to his health issue, he couldn't able to come to the court today, Lordship. I am praying for adjournment. Can this matter be taken up in next week, Lordship? Or any date as per
next week I will not be available.
any date as per your Lordship convenience.
11th March.
Deeply obliged, Lordship. Deeply obliged.
Eight কি হলো 8
M?
8
I appear. I concluded my submission, your lordships, remember.
this matter is relating to
The issue is after referral whether the overdone amount can be deducted and whether after the court's order there is any scope for denying the claim of the petitioners. These are the two issues.
yes
I'm for the state respondent.
I prayed for time to make submission.
My lord, already a rescind order has been passed, my lord.
That is under challenge.
Yes, rescind order has been passed.
Well, should
Page 50, my lord. Page 50 of the writ
50.
application. Yes.
Well, should I remind your lordships enter?
yes please refresh career advance
Yeah. Now what has happened, my lord? Your lordships kindly have a look to this order passed by this court. Page 43. The writ petitioner is taken up for consideration in presence of the learned advocate.
earlier writ petition this was earlier writ
Earlier writ petition, what was the direction? That is the principal grievance of the petitioner is that on recognition of the said school with effect from 1st May 2001, both the petitioners were accorded approval of the appointment by memo number such and such. Accordingly, they have completed 18 years continuous approved service on 30th April 2019. But on successful completion of 18 years approved service, the benefits which the petitioners entitled received till date have not been accorded in their favor. Mr. Bari, learned advocate representing the petitioner, has submitted that the approval which has been accorded in favor of the petitioner by memo number such and such from 1st May 2001 was subsequently extended by memo number dated such and such. Till date, therefore, there ought not to be any independent in sanction 18-year service benefits in favor of the petitioner. taking into account the date of commencement of the approval service with effect from 1st May 2001. The said school authority is represented by Mr. Acharya, London advocate, who supports the contents of the petition and prays for necessary direction to be issued for sanction of such benefits. However, state sponsor represented by Mrs. Bhattacharya, London senior government advocate, who has opposed such prayer on the ground that in terms of the memo dated 15 February 2018, issued by the Additional District Inspector Schools, Gangarampur Subdivision, Bunyadpur District, Dakhin Dinajpur, it appears that the post was created pursuant to the order passed by the Honorable Court on 27th August 2008 on the writ petition being number such and such. It has been contended that if the post which are being meant by the petitioners were created pursuant to the order dated 27th August 2008, in that event, the approval of the appointment of the petitioner with effect from 1st May 2001, as it emanates from the memo dated 19th July 2007, may not be constitute an approval while computing length of service. The court has heard the advocate representing the parties and perusal of the relevant materials available on record. There is no denying the fact that if the teacher is working on an approved post for a continuous period of 18 years, in that event, the concerned teacher is entitled to receive the 18-year service benefit under the career advancement scheme. It has been contended on behalf of the petitioners that the initial date of approval of both the petitioner to be reckoned on and from 1st May 2001, as it appears from the approval memo dated 19th July 2007, which is opposed by the London advocate representing the state respondents upon placing the reliance the memo dated 15th February 2018, issued by the ADI, Additional District, Gangarampur Subdivision, Bunyadpur District, Dakhin Dinajpur. In view of the aforesaid contradictory facts, as emanates from the submission of the London advocate representing the parties, this court finds it apt to direct the Commission of School Education, being respondent number 3, to take a decision on entitlement of the petitioner to receive 18-year service benefit within a period of 12 weeks from the date of communication of this order by passing a reason order. Before taking such decision, both the petitioners shall be granted opportunity of being heard. At the time of taking decision, the representative number 3 shall hear the representative of the said schools and you like the district inspector schools. The decision to be taken by the respondent number 3 shall be communicated to both the petitioner within 1 week thereafter. However, it is made clear, this is very important. If it is found by the respondent number 3 while taking decision that the initial date of approval of the appointment on recognition of the said school was granted in favor of the petitioner on 1st May 2001, with effect from 1st May 2001, if the petitioners are found to be in continuous approved service for a period of 18 years, in that event, 18 years service benefit as sought by the petitioner shall not be denied. To show my lord,
It is admitted fact that
from 2001, I have been in service. This is, if your lordships kindly have a look.
Being an organized teacher.
Of the organized
Organized
teacher. From 2001. There were legal battles on one after another, ultimately succeeded by receiving approval. Now, my lord, they have quoted everything. Now, the concluding portions of the district inspector schools, page 52. Hence, in the light of the aforesaid provision of the existing government order, and having regard to the facts and circumstances of the case, the materials on record, vice versa, the law applicable thereto, I am of the opinion that petitioners are eligible to get 18-year service benefit counting their service from 1/5/2001, but 1/5/2001 admitted, but they are not eligible to get incremental benefit as usual beyond 5 years of service for not having B.Ed degree as per provisions stipulated of ROPA 98, read with ROPA 2009. Therefore, as per existing rule, their pay is to be refixed after disallowing the incremental benefit beyond 5 years for not having B.Ed degree, and after 18 years of benefit is allowed as per rule. Manas, this order was passed on 5/12/2022.
This is the subject matter of challenge.
This is the subject matter of the challenge. Now, twofold submission I am making before your lordships. I retired.
Have you enhanced your the qualification?
No, my that is the main bone of contention, not B.Ed degree.
You will get your term. My lord is not running away. Now the question is, first, my lord, the B.Ed degree for improvement of the qualifications, in this case, my lord, it is not required at all. Because, my lord, I have been appointed in the year of 2001 to show if 2001, then, my lord, RT, they have clarified the B.Ed degree is not required. However, the B.Ed
Is there
degree,
any notification?
I will come one after another. Now, cut short the matter, I was submitting before your lordships, apart from all these things, when the order was passed, this order was passed on 5th February 2022. 5th February 2022. I retired from the service on 31st December 2022.
31st December.
December 2022. Very cut short the matter, without going all details. Whether after retirement you can recover the amount which has been given to me.
That cannot.
Now the Supreme Court, our division bench, cleared the issue. No. Supreme Court in case of Rafiq Masi 2015 for SCC, it is categorically mentions on
your prayer is twofold. One is not to deduct.
Yes.
And another is
retirement dues to be given. For this reason, the retirement dues has been employee who retired from service on 2022.
So you
now
are
it is
entitled to
26.
pension.
Not pension. Nothing has been released.
Gratuity, gratuity, other benefits are not also released.
No, nothing. Only the PF.
Only
PF. Only the PF. Now I am coming one after another.
Even if wrongly you have paid, how you can recover that amount after retirement?
No, that is, I can't.
Huh?
Candidly to be submitted, I can't.
So
after retirement, I can't. But B.Ed degree was not of it. The entire crux of the matter goes there. On similar facts, a judgment has been passed, my lord. They were also appointed in 2001.
No.
I talked about that coordinate bench.
That situation will arise when? If he was in service. But he has already retired. And this order has been passed on 5th 12 2022. He retired on 31st 12 2022.
Prior to retirement, this
Rafiq Masi case is fully
prior to retirement, this order was passed.
So,
prior to retirement, detection was made.
Less than
within 1 year.
Yes.
Yes,
within one year.
Within 1 year.
Retirement. So how you can deduct?
There I have nothing to say.
You pay the entire amount.
Your lordship, latest judgment I am submitting. Your lordship, kindly have a look to this judgment.
This one.
This one. Everything has been considered. If your lordship kindly takes up trouble.
So now you are only entitled for your retirement.
Due without deduction.
Without deduction.
Without deduction.
Deduction has been made or not?
No. Entire matter is pending. Entire matter is pending, and if the order, my lord,
implement,
then my lord, I will be. Now your lordship kindly the irrelevant portions.
But your cause of action is not arose at all.
No, because of the they say, your lordship kindly have a look what they said. Stipulated ROPA 90 rate with ROPA 2. Therefore, as per existing rules, their pay is to be refixed.
Oh, refixed.
After disallowing the increment benefit. Whether he can do that. Now your lordship kindly judgment of the latest judgment of Justice stand down. If your lordship kindly. Page 5. Page 5.
Yes,
page 5. Middle portion. Mr. Bari,
yes.
Mr. Bari, learned advocate appearing for the appellant submits that the issue concerning the recovery of the withdrawal amount from the retirement benefit is recurring feature prevailing on the country, and the apex court in content of the decision have been rejected the contention of the respondent authorities. It is within their competence to recover as and when the mistake and discrepancy is detected. In support of the aforesaid contention, Mr. Bari realized the apex court state of Punjab versus Rafiq Masi whatever sir, reported in 2015 for SCC 334, wherein the apex court has illustrated a few eventualities which rendered such recovery impossible. According to Mr. Bari, the instant case comes within the ambit of the one eventualities, and therefore the authorities cannot take a counter stand to the decision of the Supreme Court, which is law declared by its in exercise powers inherent under the Article 141 of the Constitution. Mr. Bari further submits that the ratio law declared by the Rafiq Masih Supra is further reiterated in subsequent decision of the Supreme Court rendered in the Thomas Daniel versus State of Kerala and others, reported in 2022 SCC online, SC page 523. Mr. Bari vociferously submits the aforesaid judgment of the Apex Court was considered by the division bench comprising one of us, Union of India versus Pramil Kumar Bandyopadhyay and others, wherein argument was advanced that the situation contemplated under Rafiq Masih case must be eminent and involved in its entirety and cannot be applied if once such eventually a situation is found in the given case. The division bench repelled the aforesaid contention and quashed the set aside the decision of the authority in attempting to recover, the very important one, in attempting to recover the excess amount paid to the employee in the event the same is detected after 5 years from the date of extending such benefit. Mr. Bari thus submits the authorities should be directed to release the pensionary benefit on its basis the scale of pay extended to the appellant and cannot recover the alleged excess amount overdone on the retirement benefit. Mr. Chatropadhyay, learned advocate appearing for the respondent, submits that immediately after detecting the erroneous fixation of the scale of pay for the appellant, the authorities raised the issue during the currency of the service. Therefore, the appellant cannot take advantage of the judgments rendered in Rafiq Masih. It is further submitted that the letter dated 18 June 2014, by which the authority detected the discrepancy in fixing the pay was challenged by the appellant before this court, and the writ petition was subsequently drawn. Thereafter, it is evident that the appellant was well aware that there is a wrong fixation of scale of pay. It is thus submitted that the mistake and committed by the authorities cannot confer any right into the appellant, as the said mistake is susceptible to be corrected. Mr. Chatropadhyay thus prays for dismissal of the instant appeal. The facts as adumbrated herein before being undisputed, the question begging to answer in the instant appeal is whether a situation evolution highlighted in the judgment rendered by the Apex Court in Rafiq Masih case may inure to the benefit of the appellant. It is no gainsaying the slew of the litigants are pouring in the docket of the court, challenging the action of the respondent authorities, contemplating to recover the excess amount paid to the employee or mistaken or wrong fixes as scale of pay. Some of the decisions are to be effected that the recovery and excess amount is overdone when the employee has no role to play in this regard from the retirement benefit is impossible. The other views are of the effect that mistake cannot confer any intuitive right in the employee upon detection thereof. The respondent authorities are not renewed in the power to recover excess amount, and such mistake does not confer any right in the employee. Ultimately, Rafiq Masih Apex Courts essentially laid down the sum of the situation which would render the recovery from the retirement benefits impossible in the following. Now, 18, paragraph 18, everything was quoted. The ratio of the law laid down Rafiq Masih is retired subsequent decision in the Supreme Court rendered by the Thomas Daniel Supra in the following manner. The judgment was also quoted. Thereafter, my lord, the court came to the conclusion in the last portion, page 12. These are the factual aspects. I'm not reading it. In view of the law, Lord, you got it? Page 12.
Yes.
In view of the law enunciated in the above report, we are unable to concur with the judgment of the single bench. The order imposed in the instant appeal is herein set aside as a consequence whereof the writ petition is allowed. The respondent authorities are directed to issue a necessary benefit payment order on the basis of the scale of pay lastly drawn, without deducting any amount therefrom on account of alleged excess payment due to wrongful and mistaken fixation of the pay. The entire exercise shall be compelled within 4 weeks from the date of communication of this order. The appeal is thus allowed. The interim application.
In similar situated, your pension will be as per the last
pay drawn. Last pay
drawn.
And my lord, this is a mistake. It is not a mistake. The DI said it is not a mistake. Your lordships kindly have a look to the letter of the DI, page 41.
And your appointment on the basis of High Court order.
2001. 2001. 2001. Now your lordship kindly see. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. 2001. the letter of the ADI, page 41. The teachers had joined the school 1/5/2001 as per NCT
That was not
guidelines.
disputed in this order also.
Yes.
They have admitted in there itself in order that you have joined and you are serving for 18 years.
18 years benefit was given. They said the incremental benefit.
Cannot be granted to you, and that's
And
why
now the recovery.
refixation will be done.
Refixation and recovery. Fully covered by this latest judgment I have shown to you, Lord.
Just
Affidavit in reply, my lord, may kindly take up for once.
which paragraph?
Affidavit in reply, page 8.
Page 8. Yes, page 8.
Page 8. My lord, there undertaking of the petitioner. It's clearly stated, undertake that in the event of my pay having been fixed in a manner, it is in 2020, it is written. Contrary to the provision contained in this memorandum, detected subsequently, any excess payment so made shall be refunded by me to the government either by adjustment against future payments due to me or otherwise.
So this will this will give effect after passing of judgment of the Rafiq Masih case.
And even
Undertaking.
It is there on record. I am just indicating.
Other judgment, I have given 40 because 26 lakhs, no? I have given 26 lakhs. Other judgment I'm placing before your lordships. Immediately I'm giving the number to your lordships. The court directed you return it to the petitioners. And division bench, it was challenged. Division bench said that amount should be kept in the custody of the register. And after the
this undertaking only affected when 5 years before the retirement.
And even my lord, the court said undertaking will not stand in the way because
so even prior to 5 years that can be considered.
Yes.
But here you have retired
2022.
2022 and order passed prior to 1 month.
After retirement. 1 month after retirement.
Before retirement.
Before retirement.
No,
almost 1 month.
Order passed by the Director of School Education on 5th February 2020.
And you have retired 31st.
I retired 31st.
So within 1 year.
Yes.
Okay.
You have to interest these in the
Item number 14, I am for Union of India. I am not an answering respondent, madam. I am for Union of India. But I am for Union of India.
So I am dismissing this matter. Dismissing.
I am for the petitioner. Lordship, it is a change brief. I have just received the Vokalatnama, Eventual Lordship. I am kindly, Eventual Lordship, paying for 1 week time, Eventual Lordship, to filing the
All company, madam.
You give your name.
Item number 15 to 23.
Yes.
14 was my lord.
14 কি হলো 14?
My lord, recollect, this is that matter which is mentioned for
So,
observation.
14 কি হলো?
The petitioner is not coming forward.
Prayer made by the petitioner just now. He newly appointed.
Oh, okay. lords, I appear for the petition, my lords. This is that matter, my lords, the custom matter where Mr. Abrutos Majumdar, learned senior advocate, had briefed you in the matter, my lord. Briefly, my lords, I'll tell you what is the issue about, my lords. The answering respondents are the customs authorities, my lords. The issue pertains to interpretation of SAFTA agreement, which is a treaty between sovereign nations, my lords.
Other side is there.
My lords, on last occasion they were there, but today they are not there. My lords, on last occasion I indicated to file a list of dates. I am carrying that list of dates, my lords.
I am fixing another date.
My lord, then keeps it for not today, my lords. May this make
Next day,
my lords.
not today. Simple.
Today হচ্ছে, order হচ্ছে না। Much hope.
And for the Madrasa Service Commission, my lord, Senior Advocate Pratik Dhar is engaged in court number 24. Petition is there?
Not today.
4 and 25.
Both not today. देखिए not today. Not today. None appears on behalf of the same order.
My lord, I'm for the petition. On the last
Who is the other side?
it is not
I am for the respondent number 9.
it's a Chondicharan they is
The
appearing for the
answering
state.
respondent is the state.
On the last occasion also, you lot direct me to serve the notice. Again, I have served the notice.
Have you served the government pleader?
Yes, yes, my lord. This is again I served the notice also. My lord, on the last occasion.
No, I asked you to serve the copy to the learned council appearing on behalf of the
Mr.
state.
Mr. Chondicharan is appearing.
Rajashree Roy and Miss Ravi Ranjan Kumar. Last occasion I passed this order in your presence.
Well, we inquire the office that Mr. Chondicharan is engaged in this matter.
I asked you to serve the copy upon Miss Rajashree Roy and Mr. Ravi Ranjan Kumar appeared for the respondent earlier occasion and as well as learned government pleader. Where you have served? Why you have not served? Last occasion the order was passed.
Then my lord, not
28th
no, not
January 2026.
not today. My sorry, today I'm sorry.
No, I for the state lordship. There is the opposition lordship. I signed the opposite party.
You have soft copy?
Yes, yes, yes. No one appears from.
Last occasion, you were not there.
Yes, yes, yes.
Commissioner was not.
On the matter of the vote, also I have come. Sorry. Today also petition is not.
It will remain in the same position whenever I will take. Not today. Why?
Led by Mr. Sagar Bandyopadhyay, my lord, I'm praying for a short passover.
In this matter, my lord, I am appealing for Union of India. Lordship,
Please,
kindly
passover,
grant
my
me an extension, my lord, for filing opposition. I will be just filing, my lord, within the period of 2 weeks.
This is a matter of 2023.
My lord, it's a matter of 22. Sir, kindly
Pay
grant,
the cost.
kindly grant me short time, my lord. 2 weeks time, my lord, I'll do that, my lord.
My lord, I am for the petition. My lord, is a matter, my lord, where, my lord, the petitioner number 1 is my lord the proprietary concern running my lord the business for last more than 40 years. What happened,
No,
my
but
lord?
they are on behalf of the HMC.
Mr. Sandipan Banerjee, my lord, affidavits have exchanged. Matter is, my lord, fixed for hearing.
What is the matter about?
My lord, the subject matter is this, my lord, that on and from 2020, my trade license has not been renewed. My lord, we have applied.
You are running the business or hotel?
No, we are running the business.
Business of what?
Business, my lord, hotel, my lord.
Hotel business.
Yes. We have other license, my lord, also. They are up to date. But trade license, which was, my lord, renewed up to 2019 to 2020. Thereafter, COVID intervened. And thereafter, my lord, the physical application was banned. Website application, online application. We went on, my lord, filing application, but it was not, neither it was denied to grant, nor it was granted. Then, my lord, what happened? We moved this writ application in the year 2023. Then, my lord, in the website, this, my lord, published a notification that you have to pay the license fee to the tune of rupees 11 lakhs, 12 lakhs, sometime.
For trade license?
For trade license. We were surprised, my lord, that how it can be. Trade license was 500 rupees per year, and so long we are paying that. Other charges.
Every year your license was renewed.
No. Earlier was renewed, my lord, on the payment of rupees 500 for license fee. And so by other charges are
Now
concerned.
suddenly they are claiming 12 lakhs rupees.
Yes.
For renewing the trade license.
For renewal, adding, my lord, sorry, adding, my lord, so many ancillary charges.
Is there any provision?
Well, that's my point. That's my point. Exactly, my lord, on that aspect, the coordinate bench deprecated that practice.
How can they charge?
There is no provision, my lord, under the law, under the Howrah Municipal Corporation Act.
Can you intimate the learned council? Sandipan Banerjee and Ankita Tujrekha. Can you inform? What is their opposition?
Their opposition, my lord, they have taken recourse to one provision of law of the Howrah Municipal Corporation Act. But I shall place before your lordship, there has nothing to do with the enhancement of, my lord, the trade license fee.
Suddenly 12 lakhs rupees for renewal.
Including, my lord, ancillary charges. Including ancillary.
What ancillary charges they will?
Conservation charge,
Huh?
conservancy charge, some special charges has been imposed.
Such charges was not levied earlier.
That is separate charge. That has got nothing to do with the
trade license.
My lord, may I suggest?
I think there was some dues.
Certainly, my lord.
That's why they are not renewing the license.
No, there is no dues. So, but trade license is concerned, we have applied, my lord, every year.
No, ancillary charges.
So, that have also paid.
There is no dues.
No dues.
Where is their claim?
My lord, your lordship will find.
Which page?
That in my, after, my lord, the writ petition being moved, it was came up, my lord.
You have not annexed?
Yes, I have annexed, my lord. I am filing a supplementary affidavit. In that supplementary affidavit, my lord.
Have you filed the supplementary affidavit? Have you filed the supplementary?
Yes. I have filed the supplementary affidavit.
When you have filed the supplementary affidavit?
My lord, supplementary affidavit, my lord. Your lordship will find. My lord. It was filed, my lord, possibly in the month of July 2020.
affidavit filed by the petitioner is taken on record on 24th February 2025.
My lord. And there your lordship will find page 5.
There was a direction to file report. Whether report has been filed.
That report was filed, my lord.
Corporation filed a report, yes.
That report was filed. And initial, my lord, the Justice Chandro was not satisfied.
Again, we inform the learned counsel so that in presence of both sides.
But fixed then, my lord, 11 March.
What is section 192?
My lord, section 192, I shall show to your lordship.
Your prayer is only renewal of the trade license.
Trade license with the fees, which is rational. Whether they have got any power to enhance, my lord, the license fee to that extent.
Section. Okay, you serve and then come.
Well, served, my lord. I have served supplementary affidavit. Everything I have.
I am for the petition. But the affidavit has been exchanged, matter is ready for hearing. But the petitioner, 20 petitioners, they have been working as a tax collector.
For this court when Justice Vivas Patnaik is already there. Yes,
But this is ready for hearing. This is ready for hearing.
Maybe.
But
Once it was.
I moved an application.
How it can be.
Moved the
taken by this court.
moved the writ application as listed motion.
It's not a good practice.
But this is ready for hearing. This is your
Maybe.
lordship jurisdiction.
But this was session by the another coordinate bench.
My
In
lord,
the meantime, you mention and listed before this court.
before that court, my lord, the
Whether
hearing matters are not.
is this matter?
No, my lord, this is that is
No,
motion stage.
I will.
This is ready for hearing. This matter be taken up
You ask for that court to release the matter, thereafter you assign this matter before this court, then I will take up.
Item 34, I am the petitioner, Lordship. In this petition, Lordship, I am challenging the dealership license.
এটা দেখবে না কেন, তুমি দেখেছিলেন দিলে না?
This writ petition, I have challenging the dealership license, Lordship, which is obtained by the petition respondent number 5 and 6 by obtaining the misleading by the concerned authority, Lordship. And I have made a representation before the concerned authority. That till now that representation has not been considered. And thereafter, Lordship, this court has directed to the state respondent and also the private respondent to submit the status report and also the oppositions. They have not filed. Thereafter, Lordship, the matter was taken up on another day. Lordship had directed to serve a notice to the other side. I have a served, Lordship, but till now they have not.
Where is that? Why you have not make a ready affidavit?
Lordship, this is my apology.
So that I can take up this matter. Have you intimated?
Yes, I have intimated, but affidavit of service not available.
Yes, please give. You have sent through speed post.
Yes, November I have served. Yes, notice.
Lordship, I am for the petitioner, Lordship. Lordship, it is a Group 8 matter, Lordship. Appeal connected to MAT 1543 of 24. It is pending before the division bench, Lordship. Under similar circumstances, I am paying for the same order, Lordship.
Similar matter is pending before the
Division bench.
So what do you want now?
Let the matter be out of list. Out of list.
How you can say that this is a similar matter?
Lordship, it's a dealership matter.
Dealership matter may be different. Which year? Which area?
It is 24. 2024.
You are for the petitioner.
Yes, Your Lordship.
You want to cancel or rescind withdrawal of approval of vacancy of fair price shop at village Katlamari 1. And this case is relating to challenge the vacancy notification on the ground that after promulgation of National Food Security Target published. Justice Vivas Patnaik, determination is different. You must have to submit.
Yes, ma'am.
You have not submitted. I thought the determination is with the
No.
Justice Vivas Patnaik. Where is the other side?
Left to court, my lord.
Recall karo, order to recall. Same position, you inform others.
I am good.
You must submit.
My lord, I mentioned before, your lordship, for irrespective of classification of year and cases.
Hearing is, I have a determination.
Yes, my lord.
But there are other courts
Yes.
who have also determination. That's why I thought this matter was mentioned before this court for listing. Your matter is relating to?
Relating to service or panchayat service. Irrespective of classification of cases.
Okay, no problem. Okay, now recall the order.
My lord, on behalf of
For the petitioner, my lord.
my lord, on behalf of Mr. Bhudev Chatterjee, he is appearing for another court. I pray for only for not today. Not today.
Let me continue.
Kindly date fixed for any date.
You can note it down.
My lord,
Can you note it down?
Yes, next date he will say.
kindly, my lord, any date fixed, my lord.
Dekhi. What is the matter?
My lord, this is the service matter, and the petitioner was awarded punishment in spite of satisfying the two charges, article of charges, which involves in the third article of charges. Now, my lord, the authority hold.
Okay, I will hear in presence of other side because he
Any
is
date fixed, my lord.
not today.
Mind.
I am keeping not to.
Kindly fix it. Fix the matter. This is a long pending one.
Already in the list. Whenever I will take up, I will take up. No problem. On the prayer of Lord. No.
দিন WP নাম্বার এটা আমাদের না, আইটেম নাম্বার 36।
I am for the petition.
Affidavit in opposition not filed.
Not filed, but the matter is extremely urgent, so that I mentioned before your lordships, the post may be filled up at any time. The SSC, the started process of for selection. So the petitioner was appointed to the post of assistant teacher in a madrasa, and he joined in the madrasa at Murshidabad, but he is a permanent resident of Purva Medinipur. So due to the distance, he made application. That application was granted, and subsequently, my lord, at the time when he made application, there was a, according to provision, the 10th choice. The first choice,
When you have joined the assistant teacher?
assistant teacher, my lord. In the year 2018. On 20th March 2000.
Transfer matter.
Transfer matter.
Your prayer was turned down.
Yes, my lord. What happened? Kindly, very interesting thing, page 34. There is a choice. First to 10 choice.
30?
Page 34.
No, you have applied for transfer.
Applied for transfer.
General transfer.
General transfer. And according to provision, I have given my choice 1 to 10. And transfer order was issued in my favor, and I was joined in a madrasa which is at Calcutta instead of Purva Medinipur. But subsequently, it is found before me that my choice, first choice, that post has till date, my lord, vacant. But they have given appointment in my 8th choice. So I raised objection, and that has not been considered till date.
You are working in South Chowbis Pargana?
South Chowbis Pargana. My wife is there in Purva Medinipur. She has been working as a assistant teacher of a school.
Where is your representation?
Representation, my lord. Page 38. Page 43. Therefore, 38 and 43.
43.
The first choice till date vacant, which is nearest to my residential place, and also.
And that post is still vacant.
Still vacant.
What was the ground for your transfer?
Transfer my daughter. She has been suffering in a Down syndrome, and the distance in between me and my wife is more than 300 kilometers, my lord. For your lordship, a second. Now, before your lordship takes up the old matter regarding item number 41, there is a direction by your lordship to file opposition by the respondent. Your lordship extended the time. May we file today? Because otherwise we could not serve to the petitioner.
You serve, where is the problem? I have already directed.
May we hand over this opposition to your lordship's court?
No, you serve and on that.
Unless your lordship grants leave, we cannot.
No.
All right. We shall
Already affidavit served, then where is?
Lordship, item number,
car আছে গো, এটা
Lordship, item number 43. Your Lordship, this matter I had mentioned and thereafter it had come up in the list, Your Lordship. During
taken up next day, no problem.
Lordship, on the last two occasions, Your Lordship, since it could not be taken, I've also mentioned, Your Lordship. The difficulty is that, Your Lordship, herein there was a direction given to file affidavit at a certain period of time. Now, by such time the affidavits could be filed, there was a direction that the appointment, whatever the recruitment process is, shall abide by
What is the urgency to mention this matter without calling the item number 43?
Lordship,
what is the urgency?
Lordship, the urgency is that, Your Lordship, today, if the appointments are completed, Your Lordship, thereafter, Your Lordship, the grievance which is there, Your Lordship, we are to be considered for the post of such and such. If that is not considered and the fresh appointment takes place, my entire relief goes into vain.
Lordship, I'm appearing for the Port Trust authorities in this matter.
The Port Trust.
We have already filed or served the affidavit on them.
Lordship, beyond the time period.
No, that may be true, but we have already served. And if your Lordship accepts, we can file it on the next date before the court. And also there's an interim order in their favor, which says that we have to abide by the directions of the court.
Already there.
Yes, your Lordship. That interim order is already there.
Taken up. Lordship, what I'm...
We have...
Order is there.
No, there is no interim order. The interim order is, there was a timeline given.
Lordship.
That there was a timeline given that in this meantime the affidavit has to be completed. The interim order is not given for eternity. Lordship kindly takes up the matter on the next date. Kindly fix a time.
Lordship is not being represented properly. The interim order clearly states that the process.
I cannot misrepresent this honorable court.
I will be not there.
Lordship kindly takes it up.
I will be not there.
Lordship, this week.
Next week. From next week, I will be not there.
Friday, Your Lordship. This Friday.
Friday or no, I will not take up the
Lordship then takes it up.
Petition.
Lordship, we are suffering, Your Lordship. Kindly takes it up.
They are going to appoint.
Lordship, they are ongoing process now. They are ongoing. The process is ongoing.
Lordship, if I may submit, the process has not been stayed. The interim order clearly states that the subject to the outcome of the writ petition, we will have to take a decision.
He is saying there is no interim
Lordship will kindly look at the interim order. That interim order is there.
43.
It is there, Lordship.
Interim order is there.
Yes, your Lordship.
Lordship, I'll
just not today. Whenever I will take up this matter.
Lordship, in that event, Your Lordship kindly fixes a date or a time, Your Lordship. Any day subject to the.
I can fix in the month of March.
March, Your Lordship. Lordship then kindly gives any date and of time, Your Lordship.
25th
I'll humbly pray, Your Lordship, if it is taken up.
Lordship, other side, my learned friend is present, Lordship. Some urgent matter, Lordship, very urgent, Lordship. Petition is suffering since 2018, Lordship. The HR is not being given, Lordship. Lordship, my learned friend is present. May it be fixed On the next day, Lordship,
Automatically it will be taken up. Automatically it will be taken up.
2018, Lordship, May
It will be taken up, no
It was,
problem.
my lord, heard by the district inspector of schools, my lord. Hearing was given. A recent order has been passed, my lord.
Rejected.
Yes, yes, my lord. Coordinate bench has passed an order, my lord, directing, my lord, action. My lord, he was occupying a room, my lord, which he has vacated pursuant to the order of this honorable court, my lord. Coordinate bench has passed an order. He has vacated, my lord.
Now he has vacated, now you release.
Yes, now, lordship, that is, here is the action. Here is, my lord. He has vacated, my lord. The portion, my lord, which he was occupying during that period, that has been deducted. Rest amount has been released. That is in the observation of the DI's order, my lord.
No, this is not the case, Lordship. That is not the
So
case.
I will hear next.
Wait, 3 p.m. Lordship.
No, I am not fixing any.
Lordship, 11 March, 3 p.m.
That is not so.
My lord, both parties are here, my lord. Just a necessary direction.
I am filing the opposition.
Next matter document.
And for extension of my time to file my reply, just only direction, because they now, my lord, filing the affidavit in opposition.
Next day, whenever I will take up, I will pass the order.
My lord, subject to correction. My lord, let it be. Let it be. My lord, let them file an reply. I am filing the opposition.
My lord, an order be
That
passed,
order
my
is
lord, to
required.
that effect, so that, my
Only
lord,
one line order may be required, my lord.
I can
Which
get
item?
41.
41.
Because your lordship directed for limited period. Within time, my lord, it was not taken up. That is why we are mentioning.
Extension is required, my lord, to pass necessary order to that effect.
Kindly see this order. Your lordship's order is there.
I will pass on the next day. There is no urgency.
No, no
Urgency is there.
Hold me.
All right.
Obliged, madam.
Yet, please.
How is it? Can 1 and can 2? Can 1 and can 2 tagged? Non-appeal.
But item number 45, my lord, the brief has been misplaced, my lord. I am paying for 2 weeks time, my lord, so that I can apply for certified copy, my lord.
48, I am for the petitioner. Last occasion, your lordship directed to file a exception regarding report of the Howrah Municipal Corporation. Well, I have filed this report, my lord. No one appear, my lord. I cannot serve.
Exception.
Exception.
Oh, that matter, that regarding adjustment.
Yes, my lord. Yes, my lord.
What further required?
But they have verbally requested for filing replies. And that's why I am submitting.
Reply of exception. If required, I will allow them, otherwise I will dispose it.
I'm deeply obliged. 18 months, na Dada? ওহো 2টা 20 হয়ে গেছে। আমার এটা ভুল হয়ে গেছে, তাহলে একটু কারেক্ট করে দিচ্ছি।
Correction করে দিচ্ছে?
Well, kindly give me leave to correct the number.
Just leave to correct the case number.
This is my application. এটা ধরবেন একটু?
I am for the state.
Opposition. The original opposition is not here.
My lord, we have filed a, my lord, fact statement of facts after, my lord, the application has been allowed.
So আচ্ছা, xerox
Aim of
copy
the substitution. Thereafter, my lord, we have prepared certain the report. Your lordship kindly have.
But I could not follow this thing because the affidavit they have used. No question of any statement of fact. I have served a copy of the opposition to my learned friend.
Xerox copy of the opposition already filed.
Yes.
Yes.
So that can be considered.
Therefore,
Yes, your lordship kindly consider. But there are certain facts has been, my lord, developed. That is why I have.
Developed, some certain facts developed
Yes.
in between.
We have, my lord, deposited the amount through, my lord. Your lordship kindly have a look.
What is the matter about?
But a proceeding was initiated under the West Bengal Land Requisition and Acquisition Act 1948. My property was requisitioned by way of serving an order under Section 3. Subsequently, the property was acquired upon publication of a notification under Section 41A. But the award was supposed to be declared in this case by 31st March 1995. In view of the amendment of insertion of Section 7 capital A in the statute. That was not done. Now, my lord, in between, my lord, 1990, result whereof, my lord, notice for acquisition took lapsed. Notice for acquisition took lapsed. Now, when I moved this application.
After expiry of how many years?
31st March 1995.
After 2 years.
But what happened? In 1994, there was the amendment to decide the fate of the Act of 1948. With that amendment, life of this Act of 1948 was extended till 31st March 1997. It's a temporary act. And right to requisition was taken away from 31st March 1994. Now, my lord, legislature thought that what will be the fate of those proceedings which was initiated, but no award was declared. 7th October 1996, there was an amendment to the Section 7 to the Act called Section 7 capital A. By that incorporation, award was directed to be declared within a time-bound program.
What was the time bound?
But within 2 years from if the
on the date of notification.
If the notification is being published after 31st March 1995, 91, and prior to 1991 within 1 year. So in this case, my lord, the award was required to be declared within 31st March 1995. Now, award was not declared. So statute says, my lord, notice for acquisition shall lapse. So thereby, my lord, vesting gone.
So the land
property
should be returned to the land.
Subject to your lordship correction. Property law is this, my lord, property will revert back to the requisition in view of the special bench judgment of our court. Now they were under the obligation, if they wanted to continue with the possession of the land, to acquire the land for the purpose of declaration of the award and utilize the land. What they have to do? My lord, they have to issue notice under Section 3 capital A of Section 9 of the Land Act 1894.
Further requisition.
Further acquisition. Requisition is only provided in the Act of 1948. In 1894 Act, there was no scope for any requisition.
Acquisition.
Only acquisition. There is a Land Acquisition Act. Here is the Requisition and Acquisition Act. Requisition followed by acquisition. Now, my lord, they were supposed to issue notice under Section 9(3) capital A in the instant case. That was not done. Then, my lord, I moved this writ application before this honorable court. When I moved this honorable court,
the issue pertinent to my lord section 7 capital A and the fate of those notices was pending before the larger bench. There were two conflicted decisions between the division bench and the matter placed before the larger bench. Ultimately, larger bench held no. Award is to be declared within 31st March 1995. If not so, then notice for acquisition will go. Then they have to take steps under section 93 capital A. That has been clarified. Now, my lord, in this, my lord, they used an affidavit in opposition. Two things has been stated. They have admitted that nothing has been done till the lifetime of the Act 2 of 1948. Moreover, till the existence of this Act of 1894 Land Acquisition Act, they did nothing. They said that award would be declared in accordance with the law of land. Now, my respectful submission before your lordship will be this. I understand that the steps would have been they have taken prior to repealment of the Land Acquisition 1894 by issuing a notice under section 93A or section 4, section 6, followed by section 9, etc. Then that they could have continued with the 2013 Act, the award would not been made. Now I understand, my lord, they have filed a report, although no copy has been served upon me. They have said that certain sum has been deposited with I don't know with whom they have deposited and who has deposited. Who has deposited? Now, my lord, my respectful submission before you.
When it was deposited?
Now, my lord, my respectful
31st March 2009. Last page of the report.
2009. My lord, this affidavit has been affirmed in 2016. And most surprisingly, this is not been indicated in this affidavit about the deposit of such money in the 2009. So safely this can be said it's a manufactured one. Because they would have said this in the opposition. Now, if your lordship kindly see the opposition one, this was affirmed in the 2016 and affirmed by the additional land acquisition officer.
Your prayer is here to not to proceed any further.
Yes.
So you want cancel of the notification?
No. Notification automatically gone by virtue of the operation of law.
Now, what is your prayer?
Now, P.R. Miller, kindly see. Because when I moved this application, there was a notification and larger bench judgment was not there at the material point of time. There were two conflicted decisions. One is that the thing will continue. That's why I sought for this. Subsequently, when this larger bench decision came, then my lord implied by way of statute, the notification already gone. Already gone.
Once the notification gone, you are only entitled for rent or compensation.
Yes. Rental, kindly similar. Rental compensation for the period from the date of requisition till 31st March 1997.
And thereafter?
Subsequent damage. Subsequently, my lord, there is a, I am entitled to the damage because I tell you, lordship, why. In the Land Acquisition 1894, there is no provision for payment of any rental.
For damage or compensation, it will lie.
My lord, damage for the damage, my lord, right? That is to assess the damage. Direct them to assess the damage. Or my lord, what is
how writ court can decide the compensation? What would be the compensation? What would be the damage?
My lord, for even assuming, my lord, writ court cannot. Then, my lord, they have to return back me the possession.
Possession had not been returned.
No, because they cannot continue with this because then my land has not been acquired and there is no intention to acquire even. There is no intention to acquire my land.
What is the area of your land?
My lord, area of the land is that I have described in paragraph 2. Paragraph 2.
0.05 acre.
Paragraph 2, my lord, I have stated in respect to each and every land. Paragraph 2, and there is no denial to this. Only denial in the affidavit, my lord, that plot number, your lordship, in the second plot, that is 1239 in my petition. Paragraph 2, 1239. In paragraph
Which paragraph they have denied?
in paragraph
No, my lord. I will take further time because it has been submitted by learned senior friend that affidavit opposition used is a fabricated one. Then I have to take instruction.
No, I have not said the affidavit was fabricated one. I have said the report is fabricated one, not the affidavit.
He has not said the affidavit.
Affidavit is correct.
To take further instruction because this case is 2008 before the larger bench. My lord, I don't know, my lord, what is the fact now. The fact
this matter was not before the larger bench.
I'll give you the
This
opportunity.
is not by the fate of the decision
I
of
will
the
give you the opportunity.
as your lordship.
Let him complete.
Let him complete.
Now, my lord, lordship, kindly see in respect of paragraph 2. In paragraph 2, my lord, if your lordship, for my friends are there.
Do you have the judgment of the division bench?
Single larger bench judgment.
Larger bench. The total fate of this writ petition is depend upon that judgment.
Larger bench, yes, categorically held, my lord. Larger bench. This is a reported decision, my lord, 2011 3 CHN Calcutta 555. এটা জোসেফকে দিন।
This is the relevant paragraph.
Yes. Your lordship will find up to page up to page 566. The notification amendment has been discussed. Then kindly turn to page 565. Paragraph 15 onward. আমি তো বলছি চলবে।
Paragraph.
Other matters kindly release, my lord. I will continue.
You will continue.
I will continue, my lord. After hearing the learned counsel for the parties and after going through the aforesaid provisions of two statutes, we find by the virtue of the West Bengal Land Acquisition and Acquisition Amendment of 1996, which deemed to have come into force from April 1, 1994, a duty was cast upon the collector to make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette under subsection 1A of section 4. And if such award is not made within the period as aforesaid, the said notice should lapse. I submit if you as a notice for acquisition will go. It was further provided therein that in a case where the said notice had been published more than 2 years before the commencement of the West Bengal Land Acquisition and Acquisition Amendment 1994, the award should be made within a period of 1 year from the date of commencement of that act. The date of commencement of that is being 31st March 1994. Thus, the effect of the aforesaid Amendment Act 1996 was that if any notice under section 1A of section 4, which has already been issued before 31st March 1992, the collector had failed to pass any award thereon by March 1995, those notices would lapse. Whereas in respect of the notices issued after 31st March 1992, The award must be passed within 3 years from the date of publication of the notice under subsection 1A of section 4, with the further stipulation that in default of passing of award within the time limit mentioned above, those notification under subsection 1A of section 4 issued would lapse. Now, Lordship, kindly just
These are the
kindly
two
pause.
conditions where the notification may be cancelled or lapsed.
Would lapse.
Would lapse if no such payment has been made or award has been.
Award has been award not is not made. Then notice for acquisition lapse. In this case, my lord.
In your case, they have not awarded any compensation.
No, no. Not only that, my lord. In this case, notice under section 4(1)(a) was published 19th March 1975. Your lordship, kindly turn to page 6. Running page 6 of section.
Notification when published?
19th March 1975.
Long ago.
Long ago. So, in view of, because earlier, my lord, there was no time limit prescribed.
But after amendment or.
In view of the amendment, in section of 7 capital A, award ought to have been made by 31st March 1995.
Some grace period was given.
Yes.
Such period was also expired.
Now, my lord, although this amendment, I must be candid to your lordship, although this amendment came with the retrospective effect. 7th October 1996, the amendment was passed.
The deadline is given.
Deadline given. Grateful to your lordship. Deadline was given. Then, my lord, now kindly have a look at their opposition before I proceed further with this judgment. Kindly see, my lord, in the opposition at page 4. Page 4. Before paragraph 10, the word started with I further say. Yes. Lord says got it. 4 lines before that, above, 4 lines above, there is an indication of plot number 1239. Your Lord says got it. What he has said, property requisition except plot number 1239. This is my plot.
In the same page.
In the same page, just 4 lines above. Except plot number 1239, your lordship got it. Yes. Now, lordship, kindly have a look at my writ petition.
Requisition on 22nd, 12,
they are admitting their property was requisition, but denying that this particular land was never been requisition. That is their case.
Possession was also taken.
Except this 1239. Except, yes. Now, kindly have a look at the malot, how they have dealt with without proper application of mind. Kindly have a look at malot at page 27. Page 27.
27 of writ petition.
A writ petition. I have annexed with the notice under section 3, the requisition notice. In the notice, your lordship will find there is a mention of plot number 1239. Your lordship has got it. So this is incorrect to say this property was never been requisition. Next, my lord. Kindly turn to again, my lord. Go back to lordship. Kindly, I request your lordship to go back to the paragraph 4, page 4 of the opposition.
From their document itself, it appears that the 1239 was also acquired.
Yes, also requisition and acquired, followed by acquisition notice. Then, my lordship, kindly see the next line. I further say, notice under section, lordship got it.
Yes.
4(1)(a) of the said act bearing number Ato, dated such and such, was published in the Calcutta Gazette dated 19th March 1975 for an area of such and such. next is very important, my lord. The proceeding could not be completed within the lifetime of Act 2 of 1948, within 31st March 1997.
It is admitted.
Now, my lordship, kindly at the cost of repetition, earlier occasion also I shown to your lordship the relevant provision of the act, that what was the course that would have been taken, ought to have been taken by the collector. Kindly have এটা জজ সাহেবকে দিন না একটু। মানে the left hand side, মানে this is a state amendment 9(3) capital A. Your lordship has got it. I shown to your lordship the special bench judgment, notice for acquisition got, property reverted back to requisition. Special bench said 9(3)A is the appropriate forum. We have to proceed with the by issuing notice under section 9(3) capital A. Now, lordship, kindly have a look at the 9(3) capital A once. It starts with the collector shall also serve notice. It's a mandatory. To the same effect on all such persons known or believed to be interested in any land or to be entitled to act of for persons so interested. The possession whereof has already been taken on requisition under section 3 of the West Bengal Land Acquisition Act. Herein after referred to this section, such and such. And in every such case, the provisions of subsection of section 4, section 5, section 5A, section 6, section 7, and section 8 of this act shall be deemed to have been complied with. My lord, my understanding is this, my lord. The moment this notice is being served, there is no, my lord, occasion or there is no mandate upon the collector to publication notification under section 4 or section 6. Now, why, if this is being done, because this is mandatory, you have to done, because next proviso, everything will be clear. Provided that the date of notice under this subsection shall be the date of reference for the purpose of determining the value of the market land, value of the land under this act. So, until and unless this is being issued, market value cannot be determined. And in absence of this, no award can be passed. And if no award can be passed, they cannot take the possession. Because up to section 8, everything has been complied with. Section 16 will come into play only when there is a declaration of award under section 11. Because why I tell your lordship why? Because in case of next subsection 9(3)B, your lordship will find there is a provision has been mentioned, section 16 of this act has been complied with. Kindly have a look at the next subsection 3B, next 3B, up to comply section 8 and section 16 of this act shall be deemed to have been complied with. My understanding is this, subject to your lordship correction. The moment this can be done only when there is a valid notification or notice under section 4(1)A. Notification under section 4(1)A.
4(1)A they have issued. They have admitted that.
Issue, but lapsed.
But that was lapsed subsequently. But
yes, because if in view of special bench judgment, that notice cannot be taken into consideration for the purpose of determining the market value. You have to issue.
How can they determine?
Yes. Now, my lord.
After
now, yes. Now, my lord, they have submitted a report to you before your lordship. My lord, no copy has been served upon me. I have submitted. Kindly have a look at the report. If there is any whisper or indication as to when notice under section 3A has been issued, kindly have a look at this in the report. As to when this notice has been issued, because that will be the cut-off date for determining the market value.
This is the statement of fact.
Even assuming the statement of fact, even then, kindly have a look at this. Let my learned friend indicate as to when this notice under section 9(3)A was issued. Because in the affidavit, they have not said anything.
Mauja is Bhutta.
Yes.
Your plot number is 1239.
1218, 1239 and 6996. And my lord,
But according to them, these plots are not taken.
well, absolutely false and contrary to the record I have annexed the requisition notice. Absolutely false statement. I have annexed the notification notice under section 3(1). All the 3(1) notices I have taken. And in the affidavit, there is no denial that they have not taken the possession. Except
If they have not taken possession, how they have awarded compensation? How
My lord,
they have
my
deposited?
lord, where from, my lord, I could not follow where from it has fallen that they have not taken possession. Because in the
They are standing 2 points. Standing on the 2 points. Once they are saying not taken possession.
But absolutely false.
False.
Absolutely false. Because I tell your lordship why this is false. Kindly direct them to produce
And
the
payment was made. How it can be done?
payment made.
Payment made. Payment deposited in the LA collector on my lord 2009.
But, possibly this is an unheard of law that deposit with the collector is a payment made.
No, I have not said so. I am not. It was
You have said payment made.
payment
Just
was
not you have
deposited. Amount was
As per the order of the Honorable High Court.
yes.
There is no such order. What is the order? Kindly have a look at the order of the Honorable High Court.
WP number 20988W of 2007. Well, another writ petition filed by someone else.
No, I don't know, my lord, who has filed the writ petition. And
What happened, my lord? It is such a old, my lord, matter, and the affidavit opposition used in a manner, my lord. Defending this case for the state is so difficult, my lord. I should be
also difficult from the statement of facts.
no, my lord. Whatever the
statement of
facts,
is totally.
this is contradictory as of my learned friend submitting, but it is not that. Your lordship, kindly have a look. The my lord, the
Kisan Mandal is not there.
My lord, may I request?
Wow,
My lord, may I?
Son.
They are all, my lord, substituted.
Who has substituted?
By can, my lord, 132 of 2009.
Through this statement of facts.
Yes, my lord, I will give a copy. I shall give a copy. I need, Dada.
My lord, may I request your lordship one thing?
My lord, in the next page, your lordship, 2025, they are substituted.
Have you gone to first statement of facts?
My lord, may I say something? They have said that possession has not been taken, but their own document shows that possession taken. Their own document. If your lordship kindly have a look at their possession certificate of possession at page 4, running page 4, if I am not wrong, because that has not been marked. Running page 4, certificate of possession. Next page, my lord, backside of that particular document, particular page. Your lordship will find my plot number is 1120.
1120. 1120.
Your lordship will find 1120 here.
Yes.
So this is incorrect to say that possession was not taken over by the state
collector in respect of those plots.
Possession was taken.
Possession
Only
was taken.
in respect of 1239, they are saying it is not found.
But I tell your
Other
other plots taken, and I shown to your lordship that notice for requisition. There is the indication of plot number 1239.
You go through it. Next day I will hear it.
And my lord, moreover, my lord, may I request your lordship, because they
Now
have
now your prayer is hand over the return the possession and compensation or damage.
no.
Compensation and
If
damage.
I ask for the return of the possession, sorry, my lord, I said no. Sorry, excuse me, my lord. My lord, if I ask for the return of the possession, then I cannot ask for the compensation. I cannot.
Till then, if the
rental compensation for the requisition period, subsequently the occupational charge, or but there is
that cannot be decided by writ court.
but the division bench of this honorable court said that occupational charge I am entitled to by justice presided by justice.
Entitled, there is no doubt.
By the writ court itself. Writ court
How
sitting in
writ court can assess the rent?
No, they have to assess. Only direction is there to assess the damage.
Suppose
I am not asking for the writ court to assess the damage. But whenever the direction is given to the collector to declare the award, your lordship never directed to assess the compensation or quantify the compensation. That is their responsibility to quantify.
So you will admit whatever they have decided.
But that subject to the challenge, that is not the sacrosanct. But there would be a direction for occupational charges, and this our honorable court, our court, in so many occasions have directed to the matter went up to Supreme Court. In Supreme Court also said no, you have to pay
that can be done by the writ court under Article 226, because that can be asked the government to pay compensation according to the admitted rent as per.
Yes.
If
And that
dispute
too,
is
sir,
arise, you may challenge that order before the Supreme Court or whatever. But admitted amount, if they said yes, 10 lakh rupees would be the compensation, you pay thereafter. If dispute
because
arise,
I cannot
that
ask for quantification of the compensation. I cannot.
even if they have paid the amount, as per the statute, the notification already lapsed.
Yes. My lord, may I say one thing, subject to your lordship correction? They cannot pay any amount.
No, even if direction passed by the Supreme Court or High Court,
yes,
they may deposit.
Yes.
You have not received.
My lord, there is
You have not received.
There is no direction of this our court to deposit this money in our case.
It was.
No.
No,
Kindly have a look at the justice.
You go through the report.
Yes.
You go
the
through
justice
the case number is also given.
Yes, case number, my case number is completely different. Might have been in the respect of the self-same proceeding, but not in my case. My case, Justice Bhattacharya said that you proceed with the acquisition proceeding, but not to declare without the leave of without the leave of the court.
That was the direction.
That was the direction, because the question involved in this law was pending before the special bench.
At that point of time.
At that point of time. So what steps they have taken to proceed with the acquisition proceeding?
Without permission of the court, cannot.
Without the leave of the court, but they have to satisfy. Look, I took steps for the purpose of acquiring the land. If they can satisfy, I will accept that. Let them satisfy. Judgment. And paragraph 24 is the ultimatum, my lord. Paragraph 24.
Great.